Good evening. Tonight's session is all about energy and climate change, and it's based on Bates chapter 16 at page 703 through to page 736. Climate change, says Bates, offers the ideal scenario for consideration of most, if not all, of the legal concepts that have underpinned the book. Common Law Remedies, chapter 3, International Policy and Law, chapter 4, Federal and State Governments Working in Harmony, Chapter 5, Considerations of Ecologically Sustainable Development, Chapter 7, Government Decision Making Being Questioned via Principles of Judicial Review, Chapter 20, Strategic Planning, Integrated Management of Natural Resources, Assessment of Proposed Developments, Chapters 8 to 11, Biodiversity, Chapters 12 and 13, and Pollution, Chapter 15. The weight of scientific evidence, this is at 16.2, suggests overwhelmingly that climate change is real, that it is caused by a release of greenhouse gases, and that human activities are primary cause of global warming. Given the impacts that are predicted, economists, as well as environmentalists, are demanding that governments take strong action to reduce greenhouse gas emissions. Kyoto Protocol. The starting point for discussion must be the international obligations Australia has assumed under the Kyoto Protocol. At 16.5, the protocol requires parties to account for emissions of greenhouse gases from 4 particular sources: energy, waste, industrial process, and agriculture. The different obligations placed on developed nations compared to developing nations, of course, reflects the principle of common but differentiated responsibility. At 16.9, emission reduction targets may be achieved not only by limiting or reducing emissions of greenhouse gases, but also by using agreed market mechanisms, essentially offsets, emission trading. The Clean Development Mechanism, and this is at 16.10, allows industrialised nations to invest in emissions reduction activities in developing nations and thereby earn certified emission reduction credits. Good evening.
Hello.
Just recording now, Catherine. I might put you on mute for the moment and invite you to ask questions as you see fit. To continue, at 16.12, and this is on page 707, emissions trading can occur where a party does not use all of its allowable emissions. At 16.15, at present in Australia, emissions of greenhouse gases are neither prohibited nor restricted. And at 16.20, the Clean Energy Package is the main initiative designed to drive progress towards meeting the current emission reduction targets and preparing the way to meet more ambitious targets. At 16.23, any facility that is covered by the scheme will have to surrender an eligible emissions unit every financial year for every tonne of CO2 directly emitted from a source that is the liable entity that the liable entity owns or controls. Where insufficient units are surrendered to cover emissions, a unit shortfall charge will be applied. And at 16.25, a carbon unit is personal property that may therefore, subject to the provisions of the Act, be transferred or traded. At 16.26, and this is an important sentence, the purpose of these provisions is, of course, to drive down emissions of greenhouse gases. In the end, however, the purpose of the scheme would be compromised if eligible entities could simply pay their way through the scheme, passing on costs to consumers. At 16.27, midway through the paragraph, crucially, emissions will only be reduced in the longer term by squeezing the cap. As governments lower overall caps, prices for permits and credits should rise, so long as the regulator is careful not to create too many credits, risking a flood of credits onto the market, which will drive prices down and therefore lower the incentive. The Carbon Farming Initiative at 16.28, passed into law in 2011, is a carbon offset scheme that allows farmers, foresters and other land managers to create Australian carbon credit units by carrying out carbon storage and pollution reduction activities on the land. The CFI has the potential to significantly assist Australia to meet Kyoto mitigation targets, as well as contribute to more sustainable land management practices. Energy at 16.31. Around 75% of Australia's greenhouse gas emissions come from the energy sector, and it might be expected that this would be the primary target or focus for management of energy demand and supply. The Renewable Energy Electricity Act 2000 introduced a mandatory renewable energy target, and the target has operated in two parts: large-scale renewable energy targets and small-scale renewable energy schemes. I'll move on to 16.40. Carbon capture and storage may assist Australia to reach its reduced emissions targets for gases. Australia is paving the way for the eventual storage of carbon in deep seabed geological formations. At 16.44, strategic land planning is the most obvious vehicle through which planning for the anticipated climate change can, particularly for predicted sea levels, rise. Climate litigation, this is at 16.45. The impetus for climate litigation is building through merits appeals and judicial review, with the possibility of common law claims to come. Such actions are going to present courts and tribunal members with arguments based on science as well as law, likely to have been outside their individual or collective expertise. Just stop there. Common law claims we've talked about, which are based in Chapter 3, are essentially those claims where some form of damages is sought, typically. Damages as a result of an alleged breach of common law duties such as negligence or nuisance or trespass. Merits appeals are where the jurisdiction, the authority hearing the matter, will rehear the matter afresh. And judicial review is an action where the court, typically, is asked to consider whether the regulatory authority has appropriately applied or followed the steps in terms of its decision-making process. At the tail end of 16.45, to be successful in a court, a litigant must adduce evidence to support his or her contention. In a civil matter, that will be on the balance of probabilities. Is it more or less likely? Litigation may eventually show up in common law actions. However, at the moment, the most fruitful area of litigation is judicial review and also merits appeals of decision-making. At 16.47, Bates identifies a number of significant hurdles to address, and I'll comment on those three. Number one, evidence of causation. In other words, how do you prove that the emissions from coal-fired power stations have a definable impact on the Australian environment? Number two, to convince the court or tribunal that this is not just a matter of policy best left to government and therefore non-justiciable. And number three, to target the person or organisation responsible for the claimed climate-induced impact. So they're the issues that need to be overcome in terms of climate litigation. And at 16.48, the courts themselves are not policymakers, and they have no function directly requiring societal adaptation to climate change or mitigation of its impacts. At 16.49, carbon is already acknowledged as a pollutant. Then theoretically, they can be controlled under existing legislation. So why, says Bates, is that not happening? The answer, of course, lies partly in the necessity to take a national perspective on greenhouse pollution and partly on the impossibility of retrofitting major greenhouse gas emitters to meet whatever emission standards might be developed. No one realised what we now call greenhouse gases needed to be regulated. At 16.54, when carbon trading becomes a reality in Australia, the common law concept of property rights will have to be manipulated to confer security on the property that is being traded. In other words, the carbon sequestered by vegetation and soils, or sequestered by carbon capture and storage, where there are still significant and uncertainties about property rights. To grant security for the tradability of sequestered carbon, a new species of property will need to be created by legislation. The nature of the property rights is in the nature of what the common law might recognise as a profit a prondera, which is a right to claim the benefit of certain things which are on or grown in the property. At 16.56, can cause and effect be established? Vague claims, for example, that producers of fossil fuels should be legally liable for climate change impacts to large classes of the public, are not likely to gain traction in Australian courts, says Bates. The problem besets coastal councils. Some are adopting a policy of planned retreat by buying up waterfront properties and also establishing setbacks. At 16.60, the question then arises, if such actions by disgruntled landowners suing local councils does become a distinct possibility, whether parliaments might intervene to protect councils in those circumstances. 16.64. Decision makers may be challenged for failing to take into account relevant factors. The issue of what goes to make up a relevant factor is explored in Chapter 20. It's hard to imagine these days that climate considerations would not be relevant to most institutional decision-making, and legal challenges based on the adequacy of consideration of climate-related impacts on decision-making can be expected to increase in direct proportion to the failure of decision-makers to make it clear how such considerations have been addressed. That's an important issue in relation to the question of judicial review. So read that sentence carefully. Over the page, once the relevant material has been adequately considered, however, weighting the decision-making in response to all relevant considerations is a task entrusted to the decision-maker with which a court on review will be reluctant to interfere. The point there is that provided it can be shown that the original decision-maker did give some consideration to a relevant factor, then it will be difficult to overturn the ultimate decision simply because the appeal court was of the view that the original decision maker didn't give sufficient weight to a certain factor or factors. That's on judicial review. That's not the case in merits appeals, where the decision maker will have the decision completely reconsidered by the appeal court or tribunal. 16.65, although the availability of merits appeals is more constrained by contrast with opportunities for judicial review, where merits appeals are available, then climate change might be expected to figure strongly in grounds for appeal. At 16.66, development in coastal zone might also be expected to attract a fair amount of scrutiny. A precautionary approach to development in coastal zone is likely to be applied. In Victoria, the counterpart of our QCAT, that is VCAT, continues to endorse a policy of requiring preparation of coastal hazard vulnerability assessments in appropriate cases where the costs might be quite prohibitive. In Tape's case, 2010, the tribunal refused permission to the proposal to construct 4 dwellings, which would have been subject to risks from potential impacts of climate change by sea level rise. The proposal failed to satisfy the purposes of planning for intergenerational equity, sustainability, fair and socially responsible development consistent with the objectives of the Act and the State Planning Policy Framework. At 16.69, uncertainty about the effects of climate change on availability of water supply convinced VCAT to refuse permission to extract groundwater for agricultural irrigation in one case. and applying the precautionary principle in the context of climate variability and available water resources, the tribunal concluded that the licence application fell outside the sustainability objectives of the Water Act. So in conclusion, courts and tribunals will be wary about the prospect of climate change being used as a template for opposition to all and any kind of development. While a precautionary approach to decision-making that might involve climate-induced impacts is undoubtedly appropriate, what this means in practice is that the decision-maker should go about their tasks with an eye to showing, if challenged, that the issue had been considered in the decision-making and potential impacts had been addressed. And that concludes my overview of Bates Chapter 16 in relation to climate change. Thank you. Now, do we have any questions, comments, or other issues that want to be anyone wants to raise?
No, thanks.
Okay. All right. Well, thank you for joining us tonight, and I'll stop recording.